These are the sectors where, in services industry also, Indian companies are very strong, and they're coming to Uzbekistan in big way. And of course they would like to be in other sectors also. So when the interest is increasing, I'm sure that business would also increase in the coming days. And so, though we of course don't want any disputes to come in the business, but nevertheless, you have to be prepared for such situation where alternative dispute resolution is very important. And I think that in India also, government of India has always encouraged that there should be less and less litigation, because courts are overburdened. And if the courts are overburdened and they can't give much time for dispute resolution, it means that any investor or businesses from both sides would suffer if there are no quick decisions. So ADR is a very good thing, and I think that in my ministry in Government of India, the Ministry of External Affairs always advises that the ADR should be a clause in any contract, and try to go to ADR before you actually go to court. Of course, it depends upon the parties, and that culture has to develop, that both sides go to ADR, both sides respect the decisions coming out of ADR. ADR itself should not become a long drawn legal process, because then there would be no difference between a court and ADR. And also, when we are talking of ADR, we need to also understand that there should be sufficient domain expertise available in the country, so that it may be a project of roads or water, or a chemical factory or something, and construction, hospitality. So you need very good experts, who can understand all aspects of business, the trade, and etc. And then they can help the parties arrive at a common understanding that what the dispute is about. And then the judge, who can be from legal profession, or who can also be an expert from the domain, can give his or her ruling. And then you accept it. Actually, that culture has to develop, that you actually accept and understand that, look, there was a dispute, we arrived at a settlement, and let's go forward. But if you don't accept, then you go to courts, and then it can be a long drawn process, and both sides actually lose money. So for Uzbekistan, which is at this stage of development where many Indian and foreign companies are interested in coming to Uzbekistan and going into business, they would like to be assured that there's a very clear legal base for their doing business in Uzbekistan. And in terms of a kind of dispute resolution, there are bodies which are available. So an ADR platform promoted by Westminster International University in Tashkent is very important. And I hope that what you have started and what others are looking at it, and how they are gaining grounds, it becomes an accepted culture in Uzbekistan, that don't go to courts first, go to ADR. Also, there are things about international seats of ADR. Where do you go for if you are taking your disputes abroad? I would invite you to India. I mean, India is a very, very great place, and it's next to Uzbekistan, very close. I mean, you don't have to look far to places like USA or Europe or Singapore or whatever. Come to India, and I think that we have a very good expertise developed in India. As an Indian ambassador, I'm entitled to say that. And please, I'm from the embassy, we are always ready to extend support for these kinds of activities, because it also helps Indian businesses clarify things. But even before we talk of ADR, we need a lot of clarity, legal clarity, and giving clear guidance to businesses who are coming to Uzbekistan. So I would urge all of you, all future lawyers, student lawyers, people who are in the ADR, to be available to provide these kinds of clarity to businesses which are coming abroad. I would, of course, once again, I would say that I would not want any dispute to occur at all. But if the dispute occurs, I think that ADR is a better thing to do. With these words, thank you very much. I'll stop here, listen to experts, which would be a better thing. Thank you. Thank you.
Thank you very much, Diana. Good afternoon, assalamu alaikum, everyone. So, welcome to the university. Welcome to Westminster International University in Tashkent. Your Excellency, welcome back. Always good to see you and host you on campus. Ms. Mishra, thank you very much for moderating the session. And dear guests and our students. So we're very delighted as a university to be part of this second edition of the Uzbek Arbitration Week. I think this is very important for the legal community to work and debate and learn from each other on issues of ADR and emerging debates within ADR, and learn from the experience of India and their experts. So again, we're happy to join hands and have our alumnus Diana to lead this Uzbek arbitration event with the Tashkent International Arbitration Center and the Chamber of Commerce. And again, we're happy to provide the platform on their day 3 for this event. So I hope you will engage each other today and ask good questions and learn from each other. And we're happy to hear from experts from what they have to say today. Thank you very much.
And what was commendable about all that work was vast majority of it was digital. We did not let COVID come in a way of allowing parties to access justice. We continued to educate people about TIAC, and we have such amazing supporters that I am so pleased. I don't know if I got to mention this, but we have a lot of Indian businesses, general counsels and in-house counsels who have joined us online. Very unfortunate they can't be here in person next year, hopefully. I would like to introduce our panel very briefly today, and we will be talking about the topical issues around arbitration. We've been joined by Sharina Petit. They will be giving you their introductions in greater details, but a brief one. Sharina Petit is the head of India practice for Norton Rose, one of the leading professionals who's absolutely raving the diversity flag all over the world, making us all proud. Sharina, welcome and thank you for joining us today. We are joined by Nusrat Hassan, my first boss. I don't know how to call him my boss, but I'm very pleased to have him today. Nusrat Hassan is a co-managing partner of one of the largest law firms in India, Link Legal, and he also has great ties with Indian Chamber of Commerce globally, and therefore he's just not a lawyer. He seems to be a rainmaker to me. So Nusrat, welcome. We cannot wait for your views as we go forward. One of my most favorite panel members, and I have to be biased, Bobby, is in a very last minute. He was extremely thrilled. He was actually supposed to be here. It's just last minute that he couldn't, and he believes that it's his wish, and next year he's definitely going to be here a week in advance. So Bobby's was the partner with Lusra and Lusra, again, one of the largest firms in India, leading on dispute resolution again. And more so, I resonate with His Excellency's views that there shouldn't be any dispute, and ADR precisely is the way that you resolve the differences very quickly before it gets stressful and there's total disruption of business, which is exact opposite of what parties want. So Bobby's recently merged his practice with DSK Legal. Thank you, Bobby, for joining us, and we look forward to hearing from you all that you've done and you want us not to do as we go forward. The next member of our panel is a very special person. She works for this law firm called Shardul Amarchand Mangaldas. We've worked on a lot of very complex dispute resolution matters, particularly transport, metro. The claims have run into millions and billions of dollars. And I don't know in Indian rupees, because that would mean I'll have to remember the number of zeros, but I think a lot. And in a very early stage of her career, I am so proud to say Shruti has come such a long way and recognized as one of the leading practitioners, and also a great proponent of empowering women all over the world. And I have seen her support women in general, but particularly Indian women, speaking to them, guiding them through their careers. So that's Shruti for you from Shardul Amarchand. And our very unique panel member, I think I have to say a few words about him before I hand over the mic to Sharina for moderating the session. Manavendra Mishra, we share the title. I'm not his sister, but I can say soul sister. We have been friends, and I've been his client, and he has been my client. So we've shared several relationships over the period of last 15 years. Manavendra Mishra has a very unique skill set of dispute resolution, not letting the disputes to happen in the first place. And his specialization, I can almost say with conviction, is pre-dispute resolution. I have almost always literally just gave him a phone call and said, here's a problem, can you please speak to the clients? And he's very fortunately been able to resolve the dispute before spending so much money and time and ruining our relationship with our clients, who is here today to share his views on what His Excellency mentioned, certain tips to avoid and what are the things that we shouldn't do. Enough about everybody. I am Aparajita Mishra. I work with Mott McDonald, I can proudly say it's the world's second largest engineering firm in over 150 countries with an immense presence in India and doing considerable work for World Bank and USAID in infrastructure in Tashkent for the last 30 years. I am their regional legal counsel heading their Africa, Middle East, and South Asia business. Today, we will aim at trying to keep it simple, but these issues do get complex when they get to the court of law or they get to an arbitrator. So over to you, Sharina, to get us through the engaging panel and what you've got for the rest of us. Thank you.
in conducting arbitration proceedings in India, particularly for disputes with government entities?
Thank you for the question, Sharina. I think I have spent the last 10 years representing private businesses on disputes, and we've done ad hoc disputes, that is, parties just decide who the arbitrators would be. We've done institutional disputes where organizations like TIAC administer the dispute for us. I think the biggest challenge for us is that the other party is not on the same page. We are not able to agree on arbitrators in an ad hoc arbitration. And that goes on for a very long time. That pretty much frustrates the whole idea of having an arbitration. So before you even get to a table with the arbitrator, with the real question at hand, you've spent years in the court trying to get relief to have the arbitrator appointed. Then somehow you get to the table, and then once you've got the award, the parties just are tempted to challenge it. Thankfully, the law in India has progressed, and as we will talk, and I hope Manavendra was able to shed some light, the grounds are getting lesser and lesser to challenge an award, and the quality of arbitrators getting better and better by the day. They don't say that in a hearing, but a mature arbitration panel can absolutely see through all the loopholes, and if you try to overtrain a witness, they can see it. If you try to fudge something, they can absolutely see. So the biggest challenge really is I think the behavior of the parties, and they just don't realize that. And the power is party autonomy at the end of the day. Arbitration also suggests this party autonomy. So if parties behaved a little, arbitration would see light of the day and create a success. And therefore, I particularly like to have institutional arbitration over an ad hoc, and I would love a forum like Uzbekistan, given several ease of enforcing it, and including the New York Convention signatories. Thank you. I'll keep it very brief because the answer is very simple. They're scared. They're definitely scared about the defense cost because those of you who have some experience in managing your insurers would know that a lot of policy covers also the defense cost. And they're always very nervous about how long is it going to take? Is the claim against you bogus? Because there is a beefed up claim against you, unfortunately, by the government. And it's for the sports of it. I think Manvendra and Shruti and I have worked on these matters before. So the sheer number that goes on the paper makes the global underwriters, and I can say that for our insurers in the UK and global markets in the US, they're nervous about just the claims that come in the numbers. And they get comfortable because at the end of the day, they're all not, they don't see the light of the day. The other issue that they feel is the arbitrators, they don't feel confident about the arbitrators taking a stand sometimes, and there are mixed views on that. When we go back to the underwriters and say, well, the opposite counsel had his daughter's wedding, so he needs 2 weeks extension of time, and he gets that, and the grandparents are having their 75th anniversary, so you go like, they get pretty shocked with some of the liberal behaviors of the tribunal to accommodate these kind of things. And international arbitrations, because as an international business, we were hoping to have something within the law that gives a long stop date, a sunset date to when will the arbitrations finish. For Indian arbitrations, the domestic ones, which is a defined term on the Arbitration Act, it's 18 months, but it's unending for international arbitrators. And most insurers want to know what's going on that year. They want to know if the claim has been notified. Do they have to set the money aside? Do they have to pay out? So time and the leniency and just generally odd numbers that they receive is insurers' biggest concern. And on the same token, at the same breath, I do think that they're quite confident that the quality of counsels, the quality of arbitrators are ever increasing, and they feel that Indian law is something that they can deal with.
Thank you, Aparajita. Moving on to the role of institutional arbitration, and again, Aparajita, this is a question for you. Do you think institutional arbitration is the way to go? I mean, it would be useful to see with your general counsel's hats on. And what do you think parties should consider when deciding on an institution to administer the arbitration?
I think I'm going to struggle to be politically correct, but the first thing they have to consider is what's the chances of them being sued or them suing? That's perhaps the first question that I look into. And we try to, as in-house practitioners, we view disputes very different to how our counsels view. I mean, we're on the same page, but we have a very different view. We view them as risks in our balance sheets. So we definitely do the risk assessment. We see the claims that can potentially come in, like in lenders' technical appointments. We expect a lot of third-party claims, which will be, we hope that they're in the tribunal. But if we are being sued, unfortunately, we'd be okay to go to the court. But if we have to sue, we'd like to go to a tribunal. If the amount's very high and stakes are very high, we like institutional arbitration. It's a bit of it's a SWOT that we do as pretty much somebody who has an MBA would do it. And I'm quite pleased with my experience of doing this with our managing directors. The biggest consideration, Sharina, is always that the stakes are high. We need a very good institutional arbitration with a really good pool of experts, impeccable choices of arbitrators, and it gives us peace, pretty much, I would say.
Thanks a lot. Thanks for that, Aparajita. Manvendra, it's interesting to hear your views on cost and time management, continuing on the vein of institutional arbitration.
I mean, given the fact that Diana in her presentation gave us a cost summary, and I think every arbitration institution that you speak with typically will always tell you why the costs work out better. I think Shruti also mentioned it. I mean, costs have at times been prohibitive. Like Nusrat mentioned, we are seeing arbitrations of all kinds these days. People are willing to go start a proceeding and get done with it. So unless you really find some ways to regulate your cost, I think cap is a very wrong word to use given what the underwriters feel in India. So regulating the cost, I think, is critical today. Some very basic techniques, I think, which are coming really good through in the institutional arbitration frame. Having virtual conferences, settling procedural timetables on emails without really taking arbitrator time, reducing counsel time. I think, honestly, the biggest advantage we saw of COVID was that councils were not as feisty against each other as we typically would have been otherwise, and it gave a lot of time. I mean, I'm pretty sure Shruti and I 4 years back would be scratching each other's head, like, oh, I don't want to do this tomorrow.
No, that is just you. That is
was
just
5 years back, right? So we used to work together. So, but anyway, but yeah, but now, you get a lot of indulgence from your co-counsels, and if you are if both sides are a little clear about what is the expectation, what are the timelines that they really feel is required, we have definitely seen a marked improvement on reducing the delay in just adjusting or finding deadlines. The second bit, historically, if let's say Nusrat is in Mumbai, the client is in Delhi, the GC sits out of Chandigarh, there would be a situation where they'll want everyone in one room. Let's sit together, bounce out ideas, do the draft, two review, 3 review before it gets filed. I think that is again something which COVID has changed drastically. But again, one of the best ways to reduce the internal timelines. You don't need 45 days or 60 days to file a statement of defense or a counterclaim. Just because historically that was the number that was put out because the counsel was a litigation lawyer who will go to court in the day, come back, do arbitration on his spare time. I think those are things which really need to be tweaked down. I was actually looking at the Uzbek rules. It's very interesting that they allow for only 15 days for filing a reply to the TOR, which I think is one of the most, I mean, it's aggressive, but at the same time, I think that's possibly the way to go. If you really want to regulate timelines, please find your buckets, find methods which reduce time. Red fund schedules. I mean, possibly one of the best documents that all international arbitration lawyers would have used. But if you try and use that in a domestic arbitration, or if one party is not keen to do a red fund schedule, that shoots off things by a month or two just on that one stage itself. And yeah, I mean, God bless couples who do their 75th anniversary happy, but we would love to have a little bit more of semblance wherein we adhere to timelines. I think it's time that for trials, you don't let counsels go on for 550 questions, hoping they will use 5 of them in the final argument. But allocating a fixed time, sticking to the time, taking a call on witnesses. I mean, there are times where you will find 8 witness statements, which each person dealing with, let's say, one small part of it, which could otherwise have been done in a common manner. So these are, I think, some of the important aspects to look at from a time control or managing the time. Forgot one of the best ones we have been using now. I'm sure Indian practitioners will know. Expedited arbitrations for claims below a certain amount, just documentary evidence, no cross-examinations. I think it's been a boon with the number of matters you've been able to close in the last 2 years under this procedure. Really has been amazing. And that said, from a cost perspective, I think the classic hot tubbing that Shaina, we I think spoken about it in the past as well. Put your experts in one room, go at them, get your questions done, let the tribunal ask them whatever they want to do. Whatever else it takes really to try and reduce the number of physical hearings which are not regulated. I think the time of the chai samosa arbitration days are over. We really need to move ahead and get things done because we are accountable to our clients, to the institution, and to a lot more.
Thanks, Manvendra. And you talked about chai and samosa, and I'm sure our audience wants to go and have some of that. and it's whetted people's appetites. But I just wanted to quickly move on to emergency awards. And Bobby, a quick question. Are emergency awards enforceable in India, and how can the legislation, the courts help to ensure more clarity on this?
A very quick answer, yes, after the Amazon judgment.
Yeah.
So, I think you look at party autonomy, you look at decongestion of cases, and you look at 17(1) of the Arbitration Conciliation Act, and you have the complete scheme what the Supreme Court laid out. I mean, honestly speaking, it's been some years in the taking to even get this judgment. I remember my first emergency arbitration award in Singapore. I had to come to Delhi to file another Section 9 to be able to enforce that. Because there was no law which said that, listen, emergency awards can be enforced in India. And the judge did not take that as a precedent. He relied upon it. It had only persuasive value. He went into the entire question and passed an order concurring with what the emergency award had said, but he did it on the grounds not that the emergency award was binding on him, but on a separate, on a completely independent view. So I think Amazon has said that right. It would be better, though, to have some more clarity, maybe by way of a short amendment somewhere, which would recognize this, because this is something which is completely missing in the act as of now. Unless, of course, you dovetail it into a Section 17(1), read that, and then make that connect. So perhaps something can be done there. One more question I needed to ask. I mean, honestly speaking, I'm scratching my head over it, and I don't know the answer. Is Uzbekistan a reciprocating territory for India to have the India-Uzbek arbitrations to be referred to in Uzbekistan and therefore can be enforced in India? I was checking and I found that Uzbekistan probably is not. Appy, you are not. They are not. So Appy,
so New York Convention.
Yeah. So ultimately, I mean, if we want something to be referred to TIAC, and an award is passed there, I don't know how we will be able to enforce that in India. It's just a question I'm asking this panel. I honestly, I don't know the answer. We are talking about arbitrations in Uzbekistan, but how will you enforce them in India? Is the question if you are not a reciprocating territory. Perhaps you need to do something about that. Appy, hello, you are there in Tashkent. Do something.
Yeah, just looking at appointment with His Excellency already. I'm on the case.
Excellent.
Perfect. Thanks a lot, Bobby, for that. Manvendra, quick question. Again, it's interesting to hear your thoughts on whether two Indian parties can opt for a seat abroad. Is this acceptable by the courts in India? I know there have been numerous judgments. So whistle stop, just tell us quickly what's the answer.
Yes, the answer is yes. Now you can have a seat outside India. And I think that's what Bobby was mentioning, that, what do we do or how do we go about it? Maybe an Indian law award with a Uzbek seat is going to settle that answer for us soon. But yeah, the law has been settled. There was a little bit of anomaly around it earlier, but you can very well choose a seat outside India.
Thanks, Manvendra. And before we go off for chai and samosa, last question so that we can kind of almost have come a full circle. Third-party funding. Bobby, is third-party funding permitted for arbitration seats in India? What do you think? What factors may have made third-party funding more prevalent?
Yeah, so I honestly, there is no law which regulates third-party funding in India, but India does not prohibit third-party funding. And in the Bar Council of India and A.K. Balaji case, and just read it out. It says that there appears to be no restriction on third party, in brackets, non-lawyers, funding litigation and getting repaid after the outcome of the litigation. So there is no bar. There is no regulation, but there is no bar. Unfortunately, what we don't have is a code of conduct. We don't have a code of conduct for financiers. We need to have a code of conduct which tells them that they have to maintain confidentiality, which tells them that they will not control the litigation or the settlement obligations, which tells them that they will not, withdraw the funding under any exigent circumstances. So these are some code of conducts which are certainly missing as far as India is concerned. I believe some jurisdictions have taken the initiative to have a code of conduct for financing, but I think we need to take that step. Bombay High Court, for example, has amended its Order 25 Rule 1 of the Code of Civil Procedure to allow financiers to become a party in order to secure the deposits in court. The challenges are public policy considerations, because there is a Privy Council which says that extortionate and unconscionable and not made with a bona fide object of assisting a claim would be opposed to public policy. So whatever the agreements are that the financiers have with the claimants, need to make sure that they pass this test of not being extortionate or unconscionable or not being made bona fide. Then you have problems with the Transfer of Property Act, which says that mere right to sue cannot be assigned. So the agreements have to be made with a certain intent in mind. This is not a mere right to sue which is being transferred. Conflicts of interest have to be taken into account. Confidentiality must be contained. And the other part is with regard to foreigners funding litigation in India, we have FEMA problems, the Foreign Exchange Management Act. So we have some obstacles to some hurdles. I wouldn't say obstacles. I would say some hurdles to cross when you do third party funding, but it's not banned. It can be done. It just needs to be done properly, and it needs to be done by ethical people for ethical considerations. Yeah.
Thank you. That was a very powerful end, Bobby. And with that, I want to open it up to the floor. If there are any questions, there's none in the chat box, but Appy, I don't know if you can see if there are any questions from the floor.
It's been, everyone's been digesting.
Michael has a question.
Michael has a question. We've all been all ears like little students, good little children, listening to something so engaging and so succinctly and simply put. Michael. Write a book on that. Thank you, Michael. Anyone up for that question? And I hope you were able to hear Michael properly.
So we weren't able to hear the question at all.
Why don't you just repeat the question?
It was a long question. Long question.
Mic was not working properly.
It was indeed a long question along the lines of how robust should arbitrators be?
No. I think you should come here. It's better.
Robust in terms of physical health.
Also that, so that we have less delays, and also just reprimanding parties for their poor behaviors, if I may, for want of a better word.
I didn't quite expect to be standing at the podium. My name is Michael Patrick Joyce. I'm from London, and I was saying it was a delight to be here in Tashkent and to listen to such an interesting debate. And I went back to what had been said by the first and the second speaker. And in promoting and singing the praises, indeed correctly, of arbitration, Shruti Sabharwal spoke about the advantages, but caveated it by saying, as long as the parties agree. And then giving a general counsel's perspective, Apajita Mishra then spoke about very often the parties not being on the same page. And my questions are therefore directed to the mismatch between the good concept of arbitration and the practical difficulties of arbitration. And I wanted to know the panel's views on whether obstruction of the arbitral process is a breach of the obligation of good faith. If it is, should arbitrators expressly warn poorly behaving parties about their conduct? Should arbitrators go further in being more robust by, for example, making interim costs awards against poorly behaving parties? And should indeed arbitrators ultimately threaten to strike out the pleading and the case of any party who is repeatedly distorting and disrupting the process of an arbitration? So in short, how far can arbitrators go?
Who wants to take that question? Bobby, you want to go first, given you're on our screen?
Okay, fair enough. Yeah, I can go first. I think look at it this way. The arbitrator, I mean, I'm assuming that the parties have agreed to an arbitration clause. I'm assuming that that agreement in place to have an arbitration process and arbitral tribunal is constituted. I mean, and it's been duly constituted. Because whatever the objections are to the appointment of an arbitral tribunal would have already taken place, and therefore an arbitral tribunal is now constituted. To my mind, once the arbitral tribunal is constituted, it is the judge. It has the pen in its hand. It can pass whichever orders it wants in order to ensure that the arbitration is carried on smoothly and is brought to a legitimate end. If somebody doesn't file his responses, doesn't file it after 2 or 3 occasions, the arbitrator can very well strike off the defense. If there is a misbehavior, the arbitrator can certainly say and put it down, saying that this is a misbehavior. If he wants to report it, can report it to whatever I would say the institution to which a lawyer is is amenable to. The entire process is under the control of the arbitrator. Of course, this is party autonomy. So therefore, the process, which has already been agreed to by the parties in terms of the arbitral tribunal constitution, the rules which govern it, and therefore under those rules, the arbitral tribunal will have full powers to take whatever action. Of course, what it can't do is ask him to sit up and do, to stand up and do 10 sit-ups. That's not what the arbitral tribunal is intended to do. It's not going to. Why would it stoop down to the level of unparliamentary behavior before a council or before a party who is not behaving in a parliamentary manner? So I think the power lies in the pen, and he's very well free to exercise that power.
Just if I can add to that, absolutely. I mean, like you said, it certainly is a breach of good faith obligations for someone to obstruct the arbitration process from going on. And usually we find the biggest example of that is a party trying to delay proceedings or derail proceedings. What can an arbitrator do? I mean, from experience, I can tell you that we have had situations where the arbitrator has imposed interim costs. We have had a tribunal strike off a counterclaim and defense of the other side simply because of the fact that they were trying to disrupt proceedings even in financial ways by saying, look, I'm not paying, do what you must, I'm not paying for the tribunal to be constituted. Of course, we had to, our client had to bear the cost, but that does come with some ramifications for the party that's choosing to not pay. But I guess, Sharina, you may have an interesting perspective on this simply because it's the biggest concern of due process. What do you do with an award which looks like it could even slightly be then later challenged with the due process sort of, ground?
Yeah, no, Shruti, I mean, I just think that, we're all human beings and so are arbitrators. And an arbitrator who's sitting there on the bench and seeing one party trying to scupper something that they'd agreed to, because arbitration was consensual, they agreed to put it in there, otherwise the parties wouldn't be there. And you just think, well, if from get-go they're trying to scupper what they had ultimately agreed, it always already starts putting doubts in your mind, doesn't it, about who's in breach and who's not. It's almost as simple as that. And I am all in favor of costs being, Bobby said power is in the pen. I think power is where the money is and who's going to be hit with the costs. And, there's something called decorum. There's something called, good behavior in arbitration. And there's disruption. And I don't see why people shouldn't have to pay the penalty for that. And that's the only way you're going to get people to comply.
I know I see a digital hand that's Manavendra. I have a question on that because in my experience, I've had opposite counsels flirt with one of our witnesses, and these are real examples. I'm not making them up. We've had opposite counsel, senior counsel, if I may, and thankfully these proceedings are confidential, so I cannot and shouldn't tell you anything, but they've just blatantly lied. These are all information in the public domain, and they go, well, we were not aware about these bids being floated, and the numbers that we got, they were just now received. So we would like to amend our claim to include 6 more zeros to it, as baseless as it is. And tribunal didn't do anything. I agree, they could do something, but they didn't. And as a general counsel, it is frustrating to go like, I chose you. And I wouldn't even say I pay you, that is wrong. But I chose you, I deposed trust in you, and there you go, just allowing these debaucheries, and I'd go as far as saying, I don't know, unparliamentary is not the right word, but unacceptable, definitely.
I think another aspect is the practical aspect, which when a party is being disruptive and how do you correct them, is also there is the downside of him alienating the arbitrators. And that is really is something which as a council, we all are apprehensive ultimately, because I mean, there have been many cases during the pandemic where many parties for delaying the arbitration refused to cooperate for a virtual hearing. I don't know if the arbitrators had any choice, and they would have to wait, because if he's not attending a virtual hearing, he's within his right, I mean, not to do so. And I don't know how far, I mean, then you just need to be patient, but you definitely are playing with the arbitrator's mind, and you're likely to alienate him. And that is going to reflect somewhere in the awards.
I think the more critical aspect here is also to appreciate the arbitrator's point of view. I mean, every third email will say equal treatment of parties under Article 18, not like we'll let the arbitrator forget that bit. So an arbitrator's role is also to balance out situation where they are trying to make sure that the award doesn't come across as any bias or any procedural infirmity or any principle of natural justice violation when it is finally passed. But it's very critical to appreciate, is the person or the party indulging in such request because of need, or is it a legal strategy which is well defined, or it is just being obstructive? I mean, if you can afford to pay the fees but you are not paying the fees, there is a provision to move for an interim cost. There is a provision, there's an article to ask for deposit of interim cost at the same time. But I think a lot also boils down to us as councils to try and draw a fine line as to where we say defense strategy and where it just goes to a point that you really need to push it down and try and enforce something in such situation.
Agree. I think also you and I have had several sleepless nights over trying to strategize the smallest details. And should we have time, this is a topic we would want to simply speak. I don't know about anyone else. I can definitely see our director so tempted in these, the ground realities. Unfortunately, we have a hard stop now. And thank you very much, my speakers, participants. You make this event a success. We definitely are going to explore to have these sessions virtually as much as possible. We wouldn't wait for Uzbek Arbitration Week, which we always do, to have Bobby and Nusrat and Shruti and Manavendra and Sharina and other people from India. They were all very excited to be here. Have them fly in, meet you, answer your questions. I hope the speakers wouldn't mind sharing their coordinates with our participants if they would like to get in touch. Diana, closing remarks from you.
Just wanted to say thank you for your interest, for all your support. And we are inviting everyone to the networking coffee break. Thanks, everyone.